Case number 18 for 2009, Ms. Devani.
Mr. Children and Ms. Kibaba for the state. Good morning to you. Yeah, my name is Moses Kurgat. Here together with Mr. Kennedy Echesa and Hilary Kiblanat for the first accused person. This is the correct position. There were certain directions that you gave in which the office of the ODPP were to make a formal application. I think what they have done this morning is to put in an oral application, which then runs contra to what you were directed yesterday. If they want to do any withdrawals, any other actions to be taken, then they should have made that formal application and served on us and all the parties concerned so that we can deal with the issues at hand. I think on the other limit that should have been done, we are ready to take a plea in 030, which is the current charge sheet that is in court. The 0E030 of 2024, so that our client can be considered to be released on bail. On the issue of an application,
considered one, we consider the public interest. Is it in the public interest? Two, the interest of others. That's the three-tier criteria which I shall apply in the present case. This intended withdrawal of charges against the first and eighth accused persons who have never taken plea for purpose of being charged separately, I find that's a matter that falls under public interest and also promotes the interest of administration of justice in this case. To retain first and eighth accused person in the present case will not only cause hardship, it also cause and delay to the prosecution and other accused person who have fully participated in the proceedings. But I find that will also be a defeat to the ends of justice, because at the end of the day, you have never taken a plea. You are retaining proceedings where case has been closed. Where will you be going? What's the end results? Just a defeat of justice. This oral application by the pursuing person will be drawn under Section 7A of the CPC. Accordingly, for the first and eighth accused persons, for the matter number 18 of 2009, they stand discharged. So that must be an end of proceedings in that particular matter.
Even if it was not undergoing liquidation, the second accused person was a company with many directors. That responsibility should not be saddled on Mr. Devani, who was just one of the directors. So we the bail in respect of the second accused person, the plea in respect of the second accused person. The first accused person may take his plea today. That's all.
Reply to the questions of this time the issue of liquidation of the company and contains that first and this person will be in charge the managing director of digital program company considered I'll issue the following directions. One, that the plea in respect of the second accused person, that the company, will be deferred. Pending the ruling on the preliminary issue. So we defer that one. Then meanwhile, I've placed a bit on the first accused person and the prosecution who shall file submissions. And I've also granted them leave to file affidavit in answer to the following key issues arising from this criminal objection. So there's no way you can put some document without evidence. So I've given you leave. These are the issues that you should be able to answer. The ownership and or directors of Triton Petroleum Company Limited as at December 2008. 2008 is the last date in the particulars of the charge sheets. So you can answer that. And I've given you the leave for the affidavit so that you have any search record, during the search record. Number two, legal status of Triton Petroleum Company Limited as of to date. That one now resolve the question that prosecutor raised and Council Kugat is saying that Tamara that's cabinet. So now you have all the 10. And again there your affidavit can also work. Then number three, you also tell me who is the responsible person under section 23 of the Penal Code on behalf of Triton Petroleum Company Limited, who should study for Triton Petroleum Company Limited. If it's the official receiver or it's the directors and not the directors. So there's also another issue that Council Kugat has raised about the first accused person being held to bear a burden. Maybe we should be shot by other people. Then, for now, we proceed with the issue of the first accused person plea taking, since there is no objection to this. Then at the end of the day, I'll give a date for ruling on the preliminary issue and make a note on that when we do the ruling, depending on how we give you the ruling for the first accused person. So I think that one resolved everything.
Count number one, fraudulent on 5th day of September 2008, Nairobi City County within the public owner, being the managing director of Triton Company, together with others before this court. Being the mortgagors of the volume of 19,186.130 cubic meters of AGO diesel, jointly and with intent to defraud the mortgagee, that is Emirates National Oil Company in Singapore Limited, disposed a volume of 13,054.850 cubic meters valued at USD amount of Kenya of 10 million 446.88.36 and Kenya shillings 32,046,783.66 of the said fuel to Total Kenya Limited without a consent of the Emirates National Oil Company Singapore Limited, Demokiji. Your response? Count number 6. 163 of the laws of Kenya, the particulars. On the 6th day of October 2008, in Nairobi City County, Republic of Kenya, being the managing director of Teton Petroleum Company, a duly incorporated limited company, respectively, together with others in court in case number 18 of 2009, and being the mortgagors of the volume of 4,261.203 cubic meters of Jet 1 A1, jointly and with intent to defraud the mortgagee, that is the Emirates National Oil Company of Singapore, disposed a volume of 675,592 cubic meters, valued at USD 550,020 of the fuel to Total Kenya Limited without consent of the Emirates National Oil, which is the mortgagee. Your response? Court number 8 and 30th November 2008 in the city of Nairobi, in the Republic of Kenya, being the managing director of Teton Petroleum Company, and a duly incorporated limited company, respectively with others not before ACC 18 of 2009, conspired to defraud Kenyan Shell Limited USD 2,246,491.34 and Kenya shillings 7,059,201.59 by purporting to that the Teton Company Limited had a volume of 4,449.40 cubic meters of diesel AGO held by the Kenya Pipeline Company at the Kipevu oil storage facility available for sale. Your response?
Not guilty.
Count number 4, conspiracy to defraud content 370 from the Penal Code, City, the Republic of Kenya, you being the managing director of Teton Petroleum Company Limited, and a duly incorporated limited liability company, respectively with others in the case of ACC 18 of 2009, conspired together to defraud Engine Kenya Limited USD amount of 286,908.22 and Kenya shillings 901,558.31 by purporting that the Teton Petroleum Company had a volume of 561.36 cubic meters of diesel, which is AGO, held by the Kenya Pipeline Company Limited at the Kipevu oil storage facility available for sale. Your response? In 18 November 2008 and 30th November 2008 in the city of Nairobi, within the Republic of Kenya, you being the managing director of Teton Petroleum Company Limited and a duly incorporated limited liability company, respectively with others in case number 18 of 2009, conspired to defraud GAPCO Kenya Limited USD value of 114,763.29 and Kenya shillings 360,623.33 by purporting that Teton Petroleum Company Limited had a volume of 228.047 cubic meters of diesel, which is AGO, held by the Kenya Pipeline Company Limited at Kipevu oil storage available for sale. Your response?
Not guilty.
Count number Teton Company Limited and duly incorporated limited liability company, respective the other of 2009, conspired together to defraud Hashi Ampex Limited USD of amount 114,763.29 and Kenya shillings 360,623.33 by purporting that Teton Limited Company had a volume of 0.047 cubic meters of diesel, which is AGO, held by the Kenya Pipeline Company at the Kipevu storage available for sale. Your response?
No.
Count number 7. Incorporated Limited Liability Company, respectively, together with others in SEC 18 of 2009, conspired to defraud Muloi Kenya Limited USD of amount 162,275.85 and Kenya shillings 51,919.39 by purporting that Triton Petroleum Company had a volume of 334.93 cubic meters of diesel, which is AGO, held by the Kenya Pipeline Company at Kipevu oil storage available for sale. Your response?
No.
Count number 8. Conspiracy to defraud contrary to section 317 of the Penal Code, chapter 63 of Kenya of laws of Kenya. The particulars on a known days between November 7th and 10th December of 2008, within the Republic of Kenya, being the managing director of Triton Petroleum Company, and a duly incorporated limited liability company, together with the others in SEC 18 of 2009, conspired to defraud Emirates National Oil Company, private limited, of amount of 1,685.122 metric tons, in brackets 2,129.978.07 cubic meters of jet 1A1 aviation fuel for shipped via MT Changjiang and valued USD 1,683,915.07 by issuing a false inventory of stocks held by Kenya Pipeline Company Limited on collateral finance account of Triton Company Limited and Emirates National Oil Company, private limited, sorry. Your response?
No.
Count number 9, volume of 2,000 metric tons, which is 2,360 cubic meters of diesel AGA, held by the Kenya Pipeline Company at the Kipevu.
One edge of the Constitution of Kenya, as read together with Article 10 of the Constitution there, which ensures that the accused person enjoys maximum enjoyment of rights that is entitled to by the supreme law of this country. Your Honor, when the accused when the charges were preferred against the accused in number 18 of 209 and also in E072 of 2024, which are basically the same charges that have been preferred here, or similar charges, all the accused then there is E072 of 2024, which has similar charges like the ones which the accused is facing in the present case. The bond terms that were preferred by court of similar jurisdiction was 1 million shillings. And the prosecution in E072 then of 2024 did not oppose the terms that had been requested for because they have been given in in number 18 of 2009. Your Honor, the circumstances, the documentation, the prosecution will be relying upon in the present case is similar to the documentation and evidence that they will be relying in E072 of 2024, now that number 18 of 2009 has been withdrawn against the accused person and brought into contention in the current case E030 2024. We urge that similar bond terms be granted to the accused. We don't want to argue at length why. One is that we've seen the affidavit filed by the learned prosecuting counsel, in which they have alleged that our client is a flight risk. Our brief submission in that one is that our client has never been a flight risk at any one time. While he was in the UK,
Yes, yes,
sworn by Andrew Lekamparish of Integrity Center, that is at ESCC. He says he's an investigator, and he has set out in his, yes, it's all right. No, I was just saying he has set out the details why he's opposing bail, and we are saying the circumstances under which our client found himself and the reasons, yes, and the reasons why he was in the UK. Okay. No, I think these are the issues which you're raising. These are issues you're raising as a judicial officer, because the matter is before your court. And in all fairness, I think it is good for you to make this inquiry. The reasons for
and thank you for understanding.
Yes. Reasons why he was seeking an asylum. I think these are matters that go beyond the scope of the application that is before you, and we would need then to put in written explanation in terms of an affidavit to give reasons why he was seeking protection by way of extradition, getting orders to stop extradition. The application. Your Honor, I don't know whether you could allow, because our client is here. We don't have sufficient evidence or information relating to the reasons which led to him seeking asylum. But he's here. Yes. We can take instructions. Yes.
I better give you this. Because I'm saying I will not mind granting you to do an affidavit, because already the procedure has got quite a lot that they have put, and also before me, and I'm able to internalize that, but now on your end. So I'll take that. You can leave that one for the affidavit. Probably Mr. Mbaka will add something. I can see you are also consulting with him. We have no problem. Yes, thereafter. Then you can address the other one. Yes, the second one.
So that we don't drag our client.
Yes.
Necessary documentation.
Yes.
May spill over to issues that we may raise.
Yes. Yes.
second issue, I think that tells you. The moment he brought this proceeding.
I'm facing a cell object, correct?
Yes.
That would lack a lot of information. We'd rather make a decision, no matter what kind of a decision, but without the information on the table. Because at this, we'll have later basis for us to relook at the issue. If I'm granting or if I'm disallowing, whichever way it goes, the two of you are in a context. One must fall by the wayside. And whoever falls, of course, they won't be happy. And if they wish to appeal, I want to help them to have a record. Yeah. So there's no middle ground here.
No, it isn't. In fact,
it's either way.
we are acutely aware.
If you allow me not to represent myself directly to you or put my points direct to you, I would like to just tell them 2 or 3 points which are very, very critical, which there's not been, they've been discussed about it, but from my word, mind if me telling them telling you, 2 minutes you want to please. It might be good if we can talk to you.
It is our case that after the accused person lost extradition case, he presented himself to the authorities, has been lawful and procedural. He was given 1 month's notice in the UK, he left, which he complied with. He had a chance to take off at that time. He didn't run away. And he has been in this country, and he has not behaved in any manner to suggest that he was on the run or that he's running. That is all, my honor, for me.
Your bail application decision. Your Honor, I know we have talked about the deed of settlement, which respectfully is not before you. Yes. But the client wishes to draw to your attention that he executed that deed of settlement in good faith because he wanted to come back to Kenya. He wanted the criminal, some criminal complaints to be withdrawn so that he could come back to Kenya. Your Honor, before then, the accused person was almost the leading oil marketing company in Kenya at 40% share. He had over 3,000 employees in this country. In fact, at some point, many times, he was the highest corporate taxpayer in this country. So he did not wish to run away from Kenya. He only wished that he was coming back to an environment that was fair to him. I think that point is clear, Your Honor. And then lastly, lastly, Your Honor, the accused person and it has been submitted extensively by my learned friend, Mr. Mbaka. He has close relationship with this country. The whole of his family is here. He does not own multiple passports. He doesn't have multiple passports. He's a Kenyan citizen with one Kenyan passport. Which, Your Honor, looking at the totality of the objection to his bail application, which is premised on the fact that he is a flight risk, he is willing, if to secure his freedom so that he can go through the process to deposit before his court. That's all.
The deed of settlement, Council Kugat is extensively submitted on. An issue that is not now. I've been listening to all of you there. Who are the directors? Correct? Yes. You tell me that. Then I address that together with section 23. Correct? And then council will also equally do that. And even if you do a joint affidavit on where we have no problem, we deal with it. Yes.
That's fine. I just wanted to get it.
And that event also, you also do. I need also time to do that. And most important for this particular matter, I may need a prepared report. I don't know how fast are they done here? You have not been doing it so frequently. I don't know.
They are done, I think, here.
What's the turnaround time?
It all depends on the directions of the court and the insistence of compliance. And in a matter, the Ian Georgia matter, where it was done with.
You will also need to move very fast. We do a social inquiry, a prepared report with an element of social inquiry. We find out who are these persons, the relations of Mr. Devani. Correct? Yeah. That probably they should, then I also want to find out about his behavior while being brought back. Correct? And while he had been here. Yeah, where he's living. We have never told, we have not told anything like that. Correct? Where the wife is and the son. Correct? Yeah, I know those are confidential issues, but I'll have to get to know about that. Then please, I urge you, that issue of the company, please assist the court with those materials, or those certificates, if possible. For this one, then I want to combine both the two rulings together. So that we give time for that, then I'll be informed by that prepared report. Because on my own, I can't really rush to give you a decision right away. Let's look at the diaries to see what would be the most silent point. I'll, of course, embark on the ruling immediately, but awaiting the prepared report, correct? Yes, awaiting the prepared report. And if I give the date, even if it would have come a little bit, the sooner it comes, so long as you are said with it by the date of that particular ruling, then I'll be able to consider it, and look at it and address it in a paragraph or two. But I'll never to expedite the rulings.
Your Honor, just as you look at the calendar, perhaps if you get a
earliest, which should be on 19 or 20s. Can you put on the Monday? It's another matter, that's the up to this point, if I tell you the direction that I'm giving, correct? Yeah, so you don't allow me to give you a date that I've given you either on 19th or 20th, correct? We agree on that, and I tell you what will happen with the accused person. Here and now, I've got no problem with that. I know what to say. And it's within the law.
19th is okay.
Yes?
19th.
What time?
This number what's now?
11.
Consult your senior Kugat. Your senior.
Say 11.
Yeah. Consult your senior Kugat.
Directions.
Ruling on the following two aspects. The first, in the interest of justice, I'll issue the following directions. File submissions and or affidavit with response to the criminal objection within the next 7 days from today. This one should be very brief. Don't address me on the issue of bond because you have had all your time. 2, I'll refer the accused person for a pre-bail report by the probation officer, and the same be filed on or before 7 days from today. Mr. HSM, you can do it faster than that. I really appreciate. I've given a date for the ruling, which is on 19th of August at 11 a.m. That the earliest I can give. Meanwhile, I know that that accused person shall then be remanded at Industrial TK prison awaiting